Great job, counsel, by the way. Okay, we are back on the record in A21844652C, Anna Maria Echevarria versus Zaon Collins. Okay, we're back on the record. I think we do have a final verdict form, right? That if it's not agreed to, we've at least addressed all objections to the form as it stands right now, right?
Correct.
And is it actually agreed to? Just to,
Verdict form?
yeah, I
Yes.
think the final
Yes.
form was it.
Yes. Yes.
Okay, so we
Agreed.
got a verdict form, which you'll. Go.
Sorry, just to reserve my right as to the punitive damages, but otherwise, yes.
Okay, you had an objection to punitive damages, but I'm gonna let that be on the form.
Yeah.
And obviously you made, actually Marvin's not on it at all, so the understanding is that anything awarded against Zaon can be imputed to Marvin, and there's an instruction in this set that says that, right?
Correct, Your Honor, and that's my understanding, and that's why I asked for a directed verdict on NRS 41.440, and that's why I think that's correct with your ruling, Your Honor. Sorry, I'm starting to
Okay,
get tired.
so do we,
Yes,
do we
Your Honor.
even need the instruction after the directed verdict?
We do.
Okay. Okay, so if we go through the set, obviously the first two pages need to come off because those are the, like the, I don't know, your introductory page. And then I need the Ladah law on the left side of all of them off. And then I think the first time we had an issue in this set, you have open, Mr. Chu, right? I'm sorry to put this
I do.
burden on you, but I don't know how else we can do this.
I'm good.
The first issue we had in this set was page 11, which we completely took out. And page 11 was, we also permit jurors to ask questions. So that page is completely out.
So we're completely out. Okay.
Yeah. That's gonna mess a little bit with the order of the rest of the pages, so I'll just keep in mind that whatever page number we give you now, we're gonna have to go back one. Right?
Yep.
Okay. So the next one that had a problem was 13, which was an attorney has a right to interview witnesses. I don't think this came up at all during the trial, right? So it's actually page 12 now, but it was page 13 is also out, right?
That's our position.
Nobody had anything about interviewing witnesses in this trial, right?
Correct, Your Honor.
Correct,
Okay.
Judge. It's out.
So that's out unless the deposition, if you want to argue that, but you both read deposition, so I don't see that being used negatively against either one of you. Okay,
14.
Okay, yeah, you took,
The numbers are changing.
you're going the wrong way.
okay, and then the next one that I had,
We just removed, is that nothing negative should be inferred by the fact that the parties hired attorneys?
Oh,
No,
no, I
delete
left
the
that. I
wrong
thought
one,
you guys
Joe.
stipulated for that one to come
First,
in.
You gotta put that one back.
I was just testing to see if you were watching it.
It's,
Yeah,
it's,
you passed
it's
it.
what's now 12. An attorney has a right to interview a witness for purposes of learning what testimony. And look, as soon as we get the final set here, I'll run it past what I believe are what my notes are here. But it's just what was sent to me. After I got past like the first 50, I didn't have the right instructions anymore. Fine to keep going, Mr. Chu?
Yep.
Okay, so the next one that we had an issue with, page 22, which is now probably page 20, it's your duty as jurors to consult. That just needs to be in a different place. So once we get the final set, what is now page 20 will be moved to a different location because it doesn't make sense to put that in the middle. Everybody in agreement with that?
You want us to move it right now, or?
I'm just gonna put a note on here to move so I can find them all.
Yeah, if you want to put in or to move or put, something that'll be easy to search, like 3 X's or something that's quick to write, or 4 X's.
Speaking my language, Judge.
Okay, and then the same thing with page 23, the same thing, or what's now 21. So, and we have an order issue with that one too. 24 is fine. 25, 26. We have an order issue with 27. The purpose of the trial is to ascertain the truth, which is now page 25. So if you just mark that one with whatever you mark the other two with.
Yep.
And then page 28, which is now 26, is out. Again, let me remind you, until this case is submitted to you, We read that multiple times already.
Out.
Out.
Yeah.
Okay. The next one. Page 32, which is probably now 29, if I'm keeping track correctly. Before trial, each party has a right to ask another party to admit in writing certain matters are true. We don't have anything like that, right? Because we didn't read any RFAs.
Correct, no admissions, Your Honor.
Okay, so that one is out.
And you are keeping track correctly, sir.
Okay. So now we're up to 20, I think we took out 4. Okay, this next one, page 33, before the period, but after the word facts. And may show more in closing arguments. So the first sentence will read, the lawyers and or witnesses have shown you charts and summaries to help explain the facts and may show more in closing arguments, period.
Done.
Okay, then that's fine. The next one is
I think
out.
you put, hold on, I think you put it in the wrong spot, Joe. She wanted it,
Oh, at the end
wanted
of the
the
first
first
sentence.
Yeah,
Yeah, I got it. Okay, okay. All right.
she put it in the second.
That one was actually my error and not me making sure Ramsey's paying attention. All right.
okay.
Either way.
What was 34, but is now probably 31, maybe. If during our deliberations, you should desire to be further informed, that one is out because we're using the one that doesn't have readbacks in it. Okay, so you will get one of those in, but it's not gonna be that one.
Okay.
The next one, page 35, which is now probably 30 maybe. Now you will listen to arguments at council. This is fine, but the order is in the wrong place, so we'll put it in a different place order-wise. It will be the last instruction, but order-wise, it has to be moved once we finalize. So whatever mark you did on the ones for order, please put on this one too,
Done.
okay? The next page can come out because it's just like an intro page. And the next one, the fact that a witness has been convicted of a felony, that's in by stipulation, right?
Yes, Your Honor.
Maintain my objection that it should be included, but yes, the form is correct.
That's page
Okay.
31, just of the document as it stands.
Okay, thank you. So now we're up to 32. 32 then, which is plaintiff seeks to establish a claim of negligence. We have to change this one because now it's, what do you guys want to say about Marvin Collins? How do you want to phrase this instead of, the first sentence I think is probably fine with the exception of negligence against defendant should be singular in the first sentence.
Already done.
Okay, and then plaintiff seeks to establish a claim of, I don't know, do you guys have an alternate one of these?
I would just say establish a claim under NRS 41.440, since we're citing the statute when we,
And I thought your proposed, what you sent last night or the night before had that.
I think it did.
Yeah, so.
Yeah, It
those-
says that we can take this one out if you think we're gonna find the ones that say that.
No, but it's in a separate.
We might as well make the change right now. The
Yes.
only thing I did was
Let me pull it up.
replace the words negligent entrustment with a claim under NRS 41.440.
Yeah, and I didn't have a problem with that language. Let me try to pull it up in your email.
Okay, so this one is fine. It'll read this way instead. Plaintiff seeks to establish a claim of negligence against defendant Zaon Collins, period. Plaintiff seeks to establish a claim under NRS 41.440 against defendant Marvin Collins. I will now instruct on the law relating to these claims.
Agreed.
Yeah,
Okay.
that's how they
So
have. it
that's in
phrased.
with the
Yep,
changes. Okay,
thank you.
it's done. Okay, next one. In via stipulation, that generally everyone has a duty to exercise reasonable care. The next one, I put that we need to revisit this because we have another one on page 6 of plaintiff's filing on 514. That's the same.
Sorry,
There's a
there was
typo.
some typos in this one and defense counsel fortunately corrected them. What were the typos?
So is this one out and we're gonna use a different one?
I'm
Well,
sorry, what
it
did
might
you-
be easier just to fix the
Fix it,
typos real
okay.
quick.
This was the exercise reasonable care, Judge. What?
Plaintiff seeking damages upon claims of negligence and negligence per se. That's what this one is.
Yes,
Says you,
okay,
you will note that the
So-
person whose conduct, and then there's a couple typos there. Do you know what the typos were?
yeah, plaintiff seeing the images and.
Oh, the parentheses parts were put in and that they're not on this one?
No, there's no parentheses. The parentheses are already in. We agreed with the parentheses being in.
Okay,
But, oh, somehow.
Cause that note is not on this one. If you guys have agreement as to what comes into this place, we can either take this one out and pull some of the other ones, or we can fix it right now.
Since we're on it, might be easiest to fix it right now. You can just find it for us, Stephanie.
I'll just pull up the pattern.
I copied the pattern.
I know, I didn't realize I already have it open. All right, so right here, you will note that the person whose conduct we set up as a standard is not the extraordinarily cautious. Okay.
Yeah, so just,
You will note that the person who set up as a standard is not the extraordinarily cautious individual, cautious. Not the exceptionally skillful one. But a person of reasonable.
law does not
reasonable
demand
and
a general
ordinary
standard of conduct.
prudence.
Okay, there we go. It's perfect. It's, per the pattern now.
Pattern, okay, so this one's fine now.
Yes.
And that is page
It just
33.
It needs to be legal cause, not proximate cause.
Oh, good catch. Let's see.
Where is approximate cause?
It's line 6.
Line 6 and line 12.
Hmm. Okay, maybe we just, let me go back to the
what's-
pattern.
Yeah, what happened?
So I'm on page 40 of yours, 2.1, Nevada jury instruction 2.1. That's what we were talking about.
No, we're talking about 4.3.
4.3.
Generally, everyone has a duty to
Oh, wait,
exercise.
see, this is where,
Oh,
this is where the set that I received was different than the set that I had.
Oh,
Yeah,
So we're
cause
not
like,
on the
we're all
current-
on, I'm on the same one that Miss Zinna's on. I'm on 2.1 with Zinna.
I,
yeah. You set up.
Oh.
On a standard, and I'm some caution individual.
all right.
Is it 2.1?
2.1 is the next one. So what
2.1
that's
is
worth.
next
So
one. Okay,
maybe we're
so-
not that far off, but, so-
Okay, so typos fixed in 4.3 at page 39. I'm fine with that. Okay.
Oh,
okay. I'm just gonna leave that here for now and we'll figure.
okay,
it out.
that's why we were so off on the numbers, cause 40 is the one that has cause on it. I don't think 39 has cause on it.
It does not.
Or what is now 36 and probably 37.
It's actually, I'm on 33.
Oh, so we took out
We've
more.
taken out, I think we took out, 4 before the, before that break page, and then we took out the break page.
It's okay, well,
And
I'll
I
check
think
it
we've
again.
taken out one more sense as well.
Okay. Okay. So 33.
So the next one I have is 2.1, which is now page 34.
Okay, so the issue with 2.1 is I put needs to revisit because on page 6 of plaintiff's filing on 514.
It was 2.1, you just needs to say legal cause instead of proximate cause under my notes.
And that's page 6, I mean, line 6 and line 12.
Yes,
If that's the only problem,
that was the only problem.
okay, so. Are you able to make that change, Mr. Chair?
Yeah, I'm on.
Legal cause of is death, so number 2.
Like that has the.
I think we've got it fixed now. So all the proximate have been changed to legal.
Okay.
Okay.
I thought it was still illegal. Is it illegal or is it the legal?
A legal cause.
I thought it was all illegal
Yeah,
cause.
I agree.
That's how it is.
Okay, I thought you said that, but okay. The next page I believe is in by stipulation, which is the preponderance or weight of evidence and not necessarily increase with a greater number of witnesses.
Okay.
The next page, I had the defendant stipulates with the typos fixed.
Correct, and then changing proximate to legal.
What type?
This is 4.9.
That plaintiffs, it should be apostrophe S decedent was negligent. Or actually S apostrophe, because we have more than one plaintiff.
I mean, we're kind of going back and forth, to be honest, with singular and plural.
Oh, okay, well, whatever you guys want to do, but the line 4 doesn't have the apostrophe
got you.
S or S apostrophe, so it needs to have one probably.
Understood.
And then you left in like his, hers.
Oh, it's her up here.
And here.
That I didn't even notice. Oh, it's her death. His death. I only saw that one typo. Okay, So that one's in after we fix the typos. The next one, I had waiting for ruling on 41440. So this is about negligent entrustment. So does this one come out?
Yes, Your Honor.
Okay. So page 43, which is probably now like what, 37?
Gold star for you, Judge.
Is out, thanks. Okay. Did we,
You have a little sticky book.
do we have anything that gives a 41440 instruction?
They have prepared one. I
It's later
agree to
on.
it. No, I'm not sure it's in that list, but it was sent in a separate email.
Yeah.
Okay,
We opened up this set, Judge, just because that's the one you indicated. you
that's
were
fine.
working
Let's
off
keep
of.
going through
Yeah,
this.
okay,
And when we
no.
get to that, I'll just put a note that we need to make sure we have a 4140.
Put that note right here.
41440 needed. Needed still. Okay,
No, NRS 41.440 needs to go here.
well, this order is gonna be all
Oh,
messed
she's
up
gonna change the
anyway.
order.
Yeah, we're gonna,
But it just needs to be somewhere in here. So the next one, every person has a right to expect that every other person will use reasonable care. It's my understanding this one's in, right?
yes.
Okay. The next one, okay, this was where I asked you guys if you wanted to,
Sorry, can we go back to the other last one
sure,
real quick? This includes the bracketed language, right? Or
I
will,
was fine with,
yes, okay, I'm good with it. Just making sure. Thank you.
okay. I think the bracket language was the or will violate the law, right?
Yes.
Okay. So this next one, these next three, I think, were the negligent entrustment, where I talked to you guys about maybe putting these all as one, or what, did you propose a later instruction on this?
So 45 is just the rate of speed instruction.
Okay,
So I think the only change on that was just correcting proximate to legal at
okay,
this point. And then 46 and 49 are where I proposed one for at my page 18 of my submission.
okay, so there's an alternate proposal here. Have you guys looked at her alternate proposal?
I don't think I have a copy.
Do you need me to print it?
Is it in your most recent filing?
I filed this one on 5/15/25.
I could go make a
Okay,
copy.
I know I have it here. What number is it on that filing, Stephanie?
Number 18. So my page 18 on that filing was meant to combine plaintiffs proposed 46 and 49. And I also.
Okay, so
included-
45 is in, or what is now 40?
Yeah, 45 with the change of proximate to legal. And I also included the definition of vehicular manslaughter, because that was his other count, and that was not anywhere in your set.
If we're gonna use any of these, I'll probably need them in Word.
Yeah, that's fine. I will-
Winding fonts.
Oh,
Are you sending it to him?
I think we're gonna,
I'm sorry, I'm looking at it.
Yeah,
I
we're gonna-
apologize.
Oh, okay, before you decide, that's probably good.
Yeah, I'm just, if you can just give me
Yeah.
a second. Okay, just. Do you know which number what mine was, Stephanie?
46 and 49.
So my language was, so I think the issue I'm having is the language where under Nevada law, so lines 20, 21, 22, and 23. My language was under Nevada law, these convictions are conclusive evidence of all facts necessary to impose civil liability. That comes out of,
I included that.
But this says, if an offender has been convicted of the crime which resulted in the injury to the victim, the judgment of conviction is conclusive evidence of all facts necessary to impose civil liability. It says which resulted in the injury to the victim. I don't think it needs to say that because the conviction is already pleading to causing injury to the victim. Does that make
So you
sense?
just, under Nevada law, the judgment of conviction is conclusive evidence, like you want that, everything from
Yes,
between both commas out.
yes.
Okay.
Yes, so under Nevada law, this judgment of conviction is conclusive evidence of all facts necessary to impose civil liability for the injury.
Okay.
Are you where? Are you,
I don't have it. She has to send.
okay.
Oh, wait, we're just working off the computer. Yeah.
Can you email us just that one?
My assistant is right now.
Oh, great.
Well, she's emailing you the
The
word
the
copy
word
of
copy.
of
Thank
all
you.
of mine.
Okay.
But you're good with combining your 46 and 49 into 18 then with that modification?
My 46 and my 49. Let me look at my 46 just to make sure.
Do you think maybe it should say under Nevada law, this is conclusive evidence of all the facts necessary to post civil liability, not this judgment of conviction? Because we're
I'm
not
fine
saying
with that.
Yes,
above judgment of conviction. I just don't want them to think that. Okay, so under Nevada law, this is conclusive evidence of all facts necessary to impose civil liability for the injury.
yes, Your Honor. Did you get their email?
Mm-mm.
We haven't gotten the email yet, though.
Okay.
All right. See if she's-
All right.
Is it in your most recent email? Cause I can forward it.
I don't know if she sent it to you. or not.
Oh, I see.
Let me see if I can find it.
Got it,
Oh, she's got it. Okay.
just now.
It's gonna say she's good.
And if in your set, maybe for now, we stick it right here,
Yeah,
just so we, when we print this set, you guys can both check it before we start to move stuff around to make sure it's exactly what we just agreed to.
Okay.
yeah, replace this one. There wasn't.
And I'm gonna go print out what I believe are the changes for you. Here's the language that I think we all just agreed to on that one.
May I approach?
Yes, please. And I'm only giving 2 copies because there's gonna be.
Call from somebody of my kids on a field trip. Do you mind if
Go
I?
ahead. You wanna? Yeah, we won't do anything while you step out of the room.
Someone's trying to reach out to her about her car's extended warranty.
Is that what it said?
No, I'm kidding.
That can't be right. It can't be one subsection one. I just made it 1A.
Okay.
I think that's gonna.
For the second one,
I want to get rid of all the numbers and letters because it's, they're, jury's gonna try to line them up with the count
Yeah.
1 and count 2.
yeah, I don't disagree, but we'll hold off for Stephanie.
Okay. So we'll do that and we'll make sure she's good with it when we get back.
So for done buying 150,000 mile bumper to bumper.
But while she's out, do you mind if I come over there and ask you a quick question?
Sure.
Got,
Come on over.
these are your proposed, so I just want to make sure they're in. So we've got. First is that one, we already talked about that. Yeah, so that one's good. One other is separate. Is this how it's framed now? Since it's not negligent entrustment, it's.
Yes. I don't know that we need this one anymore. We have the other one replaced it. Does that make sense?
Yeah.
These are the same.
Would you mind pulling up that one? up? I
Yes.
just want
You
to.
can pause it for a minute since she's out of the room anyway. Then you guys don't have to worry about whatever. Okay.
Oh, I know, I can't do that yet.
Thank you. I'm sorry.
Good to keep going.
We'll circle back.
We're just, if we could just change the,
Yeah, so we were talking about this.
Yeah.
They said they wanted to 86 the numbers just because it.
Oh, yeah, that's.
But then, are we just leaving it is unlawful for a person to space, because then we have that basically twice in a row like that? Or should I just combine that with the language of the paragraph A and then just
I
correct
will
the,
trust your formatting.
You're saying you just want it for reckless driving is defined as.
it is unlawful for a person to drive like seamlessly drive.
Yeah.
the
Oh,
D and
yeah.
Drive lowercase.
so
That's-
we don't even need the one in the A.
Correct.
Okay, perfect.
Got it.
Yeah, you can even get rid of the colon and the capital D.
All of it. Okay, so we're striking plaintiffs proposed 46 and 49 and replacing with defendants proposed 18 with the modifications.
Yes.
And you guys have agreed to the modifications.
Yes.
We agree to the modifications and we're just taking out the numbers to make it clear.
Fine. And you both agree that the modifications are consistent with Nevada law, right?
Yes.
Yes.
All right, we're good with that
And
one.
that is, as it stands now on page 39.
Okay, so page 40, which was previously 47. There was in force at the time of the occurrence in question, a law which read as follows. The driver of a vehicle within an intersection, it's the left turn statute.
Yes.
And this one is in, right?
Yes, it just needs to be changed, proximate to legal.
Yeah, and I'll obviously do a search at the end of this just for that, but
Yeah,
yeah, it's good,
just flag it
good
out
catch
for
along
you.
the way. You know, I appreciate it.
It's like around line 11 that I can see. I only seen it in one spot, but it might be more than one.
On it.
Okay. That one's in, and then, are you ready? Are you okay with us moving on, Ms. Chu?
Yes, Judge, thank you.
Okay. So in the next one, I had this one noted for us to review. There was in force at the time of the occurrence in question, a law which read as follows. Is my understanding that this law is for everybody, even people under 21? You guys have the same understanding?
Yes.
So,
I proposed a competing instruction at my page 19.
you find the defendant violates 4C? Is that it?
Yes.
In similar vein to, I'm sorry,
Go ahead.
can I, instead of the number 4 and the whoopses there, and then beginning with a lowercase I in it is unlawful, can we just make it say it is unlawful?
Well, that might change because I have a competing one that doesn't have that at all. So,
Okay, well, to the extent that,
to the extent we can tinker with the formatting, yes.
So have you guys seen the competing one, page 19 of her filing on 5/15 and her Ms. Zinna?
was this in the emailed ones? that I just
Yeah, it's
received?
right here. Yeah, it's page 19 of the one she sent.
The problem is gonna be, where do we tell them what 484C110 is?
And we can include that language, the legal language in this as well. I think it can be included. but I think it needs to be. This one isn't a. Proximate legal cause, this one is the clear and convincing standard.
I think this instruction is too wordy. If you find defendant violated NRS 48.4C.110. And that plaintiff suffered damage as a legal result of that violation. And that defendant is liable based on that conduct.
It's 12.1.
Yes,
Let me pull up one job. I told them.
Did you only raise the marijuana issue in your complaint in terms of punitive damages, and it's only raised in the punitive section?
Oh, sorry. Were you
it's
asking?
our position, yes, I don't know.
What was the question? I'm sorry, Your Honor.
Did you only raise the marijuana issue in your complaint in the punitive sections?
I'm
You don't know,
sorry.
you can say you don't know. I have your complaint
I
somewhere.
have to look at the complaint. I'm not sure, Your Honor. Do you want to check that? Or do you want me to continue?
It
looking at
doesn't
this
really
instruction?
matter. I just, the way this instruction is written, page 19, well, I'm a little bit confused about it. I'm kind of surprised that this is 12.1. Did you add the first paragraph or that was already there?
I added, if you find defendant violated NRS as to replace some of the bracketed language, but this is 12.1.
12.1 reads, if you find that plaintiff suffered damage as and then there's two bracketed words, one is proximate, one is legal, result of the defendant's conduct, and that defendants are liable based on that conduct, you may then consider whether you should award punitive or exemplary damages against defendant. Punitive or exemplary damages are to make an example of or punish wrongful conduct. You have discretion to award such damages. Blah, blah, blah.
This is the problem. I think there's a different instruction for punitive damages under intoxication. Can you search under because I proposed a different one that's a standard instruction. Under my proposed, can you search for NRS 484? I think it's 53. This is JI 12.
Operator of motor vehicle 12.3.
Yes. This is the standard jury instruction for consumption of a substance behind the wheel. So I think that it's confusing because she's combining a different jury instruction on punitive damages with.
Okay, so did you look at 12.3?
I did.
I'm gonna look at the use note because I wonder if the use note says you should only use one of them.
At least I told them I did it. I said modified. I didn't do it without.
So 48 is kind of bleeding into the same vein as we had with the other rules of the road or the other convictions being separate and apart. So if we want to mimic what we did with on my page 18, where we said Zaon pled guilty to the following charges, and that's conclusive evidence. If we want to say that, there was in time at the occurrence of question, a law that read this, but the way 48 is read does not have the clear and convincing evidence standard, right? So it's not a negligence standard for the page 48.
I'm happy to include the clear and convincing words onto 12.3 if they want, but 12.1 cannot be given in this phase because it talks about the standard for collection of punitive damages, and they are not talking about how much money to give in punitive damages in this phase. That's why 12.1 cannot be given in this phase.
And 12.3 is specifically carved out for these situations. I mean, look at the use note. It talks about attaching 484C.110, which is precisely what we're citing.
Well, the problem I had with And again, it just goes back to the problem I had with, you had 48 and 53. The 48 is a misstatement of the violation of the law paragraph, and again, I don't think it should be separate. I think we're
Can you
going
give me the word-
to,
Can you give me the words that are, that begin that instruction? Because 48 doesn't help me right
oh,
now.
I'm sorry, there was enforced at the time of the, it's the one with marijuana, check marijuana.
Got it, we're good.
It's probably about 41 for you now.
How is 48 a misstatement of the law? It's a quote right from the statute.
No, the paragraph that says a violation of the law constitutes negligence as a matter of law. It has to be clear and convincing evidence for this.
I think what Ms. Zena is saying, or at least I'm understanding it this way, that because you brought this under the punitive, the standard is not the same versus this instruction presents it in a way that this is the regular negligence standard. Because of where it's brought in your case.
Yeah.
So I understand what she's saying. And the problem is, if this is only in your complaint under the punitive stuff, then
Well, this is the problem. You don't have to cite specific statutes for negligence per se, Your Honor.
no,
So
but this one would say, if you find that a party violated a law just read to you by clear and convincing evidence, it's your duty to find punitive damages. That's what this one should read, instead of how it reads at the bottom, because of how it's pled.
I'm fine with that. I'm fine with changing this language and then including instruction 12.3.
So the first sentence should probably be out. And it should say something to the effect of, if you find that by clear and convincing evidence,
Yes.
if you find by clear and convincing evidence, a party violated the law just read to you,
The following law. And then,
yeah, or the law above, or whatever you want to say, it is your duty to award punitive damages.
okay, so do you want us to take
Or
out
it's your
the, do
duty to fine for punitive damages, something to that
you
effect.
want us to take out that there was enforced at the time of the occurrence in question law, which read as follows? Do we leave that in?
I think that stays,
Okay, so
but the language at the bottom just has to be revised because this is for the punitive, so
So if you find.
by clear and convincing evidence, a party violated the law just read to you, it's your duty to find punitive damages.
I don't think it would say it's your duty, because it would be, the
Oh.
statute is, you may. You have the discretion, so the 12.3 reads, you may consider whether or not you should award punitive damages.
Well, no, the discretion is whether it's clear and convincing to them. If they find by clear and convincing evidence, then they are to. Judge, can we change a party to defendant Zaon Collins? Is there any, I mean, that's the only.
It is just Zaon Collins.
Individual
this is
yeah,
being
I
alleged
want to make
against.
sure they know.
Yeah,
that-
I think you can
they're not-
change that. Any objection there to changing that?
I don't have an
Yeah, 'cause
objection.
No,
Yeah.
no.
I
So
don't
if you
believe
find Zaon Collins violated the law just read to you by clear and convincing evidence, it is,
So the law, I don't have a problem with the law being involved in this, right? So it is unlawful for any person to drive or be in actual physical control of a vehicle with these levels. And then adding 12.3 below that, like we did with the other one, and say, if you find that plaintiff is entitled to compensatory damages for the harm caused by the defendant's breach of this obligation or breach of this statute, we could put instead of obligation, you may consider whether you should award punitive damages against defendant Zaon Collins if the plaintiff proves that 1, 2, and then the purpose of punitive damages.
So you're saying to combine 48 with 12.3.
Yeah, I'm saying combine your 48 with your 53.
I'm a little bit worried about giving them 12.3 now. Oh, no, sorry, 12.1 now, but you're saying 12.3?
Yes.
Yeah, and if we combine if we combine 48 with 53, which would be the 4.13 modified with 12.3, I don't have a problem with that.
The law on this instruction, is that 484C110?
Yes.
So you actually could just take 12.3 and then immediately underneath it, put the language of it's unlawful, or something to the effect of 484C110 reads as follows. Cause it says in the use note for this to put,
That's excellent.
We're fine with that. So we'll have 12.3, and then at the bottom, we'll just have is unlawful, and then put the statute.
or NRS 484C110 in relevant part reads. And you put this language.
And we're including the entire form
Yeah.
instruction.
Well, in the entire form instruction for 12.3. Followed by,
Well, my only suggestion actually would be to flip that, so they get the law first, and then if they find, so then the instruction would read the law. And then if they find that the defendant breached its obligation under the law, then they can move on to 12.3. So I think providing the foundation, so just flipping it.
it was 53.
Oh, yeah.
Hold on, Stephanie, sorry, so you're suggesting flipping them?
So putting the law first,
So you want just an instruction that says it wasn't forced at the time of occurrence in question of law, which reads, and just have the law listed and take out that last paragraph on this. And then put this as the immediate next page.
well, I was gonna say the same page like we did for the
Right
reckless
underneath
driving
it.
issue. Because I don't think it's big, I don't think it's too much for one. If we're not using 12.1, if we're gonna use 12.3, I think it's fine.
Where's the law?
Time of the law, yeah.
Cause otherwise it doesn't make sense that they're being asked to discuss whether or not somebody violated or breached an obligation. Before they say the actual law that you're saying that was breached. So I just, again, being a little pedantic.
Well, it does say the law though, because what page number is it for me? 53. It says NRS 484C.110. Right there.
Right, so before you say NRS 484C1110, why don't we define it first, is my point. So 484C1110 reads, it is unlawful. And then after that, if you find that plaintiff is entitled to compensatory damages, and go from there.
Can we start with there was a law enforced time occurrence? In time question with which read as follows, and then put as unlawful.
So why don't we put, because we to mimic the one we changed for reckless driving, we had reckless driving as defined as, why don't we say, actually, no, that's fine. There was enforced at the time. Yep.
Can we,
But
You need to have 484C on the first one if you're gonna cite it in the second one, so people know what you're talking about.
That's, yeah, and that's what I'm saying. It
Okay.
needs to, the definition needs to be first before the instruction.
okay,
So-
yeah, I would agree, we're putting this together, can we change in terms of the first paragraph of the second portion of that instruction? If you find that plaintiff is entitled to compensatory damages for actual harm caused by
defendant
Zaon
Zaon
Collins'
Collins.
negligence,
Yeah, because we don't want to
instead
get
of,
confused because there's nothing to do
But-
with Marvin
Well,
Collins.
because it's not his negligence. and
Okay.
He's violating the statute, right? So breach of an obligation, I think is the stock language, and I think that's fine. And then you may consider whether or not.
by defendant Zaon Collins.
Yeah, that's fine.
Breach.
We say change to breach of obligation instead of breaches of an obligation.
Yeah.
May consider whether you feel.
So then you gotta just add the last sentence back. So if under number one, we change it to defendant Zaon Collins willfully consumed or used. Make sure there's no confusion with Marvin Collins. And number two, we're gonna do the same thing.
Yes.
Harm to.
Yeah, and since it's the decedent, can we say harm to the,
Can we say,
to Eric
so
Echevarria?
subsection 2 of the second part?
Why don't you say the plaintiffs? Sorry, Your Honor, we're just the format.
No, I'm not upset with you guys. We're getting it done. I have a little bit of headache, but I have nothing to do with either of you. Last year.
Bless you.
Sorry. What's the change?
You got it at the last sentence from the stance
Oh,
of the
yeah,
stock.
okay, yeah. You guys want to hear a joke? A joke. Remember when we thought we might get this done in 20 minutes? That was a good one. That was a good one.
Fair enough, I was wrong.
Okay. Oh, no, that wasn't aimed at you.
I don't think you thought it was gonna get done in 20 minutes either. I think you just didn't want to.
I was
We'll put
hoping
on
we
one.
could, I was thinking like an hour,
I was thinking an hour too, and that was.
and that was grossly optimistic. You would think I'd know better by now.
The jury would have rage quit.
Okay, so it looks like we got that one, right, Joe?
Yeah, do you guys want to come look at this? Because it's such a,
Can you just,
I can, but I mean,
yeah, I'll come look.
yeah, I mean, just,
That's fine.
because we're gonna send all of them over, but just so.
Yeah.
Just don't eat Joe's burrito.
Yeah,
He's
okay.
already.
I'm
Wait,
gonna eat
wait,
Joe, I'm
Can
starving.
we, oh, can we just do this?
Yes.
Okay, no.
Yes. As it stands right now, that looks like what we were talking about. I would just need to confirm and go through it.
Sure, okay,
Thank you, Joe.
thank you. Would there be any objection to if we, and we're just kind of thinking out loud here, but adding an instruction that defines highway, just because we've we've
Using
done
the
that before?
statutory definition is a good idea because it's a confusing term.
Yeah, no, it is.
Thank
I'm-
you.
Yeah, agree.
So
Okay,
we
let's look into it, and then if we want to do it, then we'll propose it. Okay, but
I looked it up last week. So.
I remember when I first started practicing, I was like, oh, none of this applies to me. So I was on Rainbow, you know?
All right.
All right.
You
We're,
guys good with
okay,
this
so,
instruction, or do you?
yeah,
need
so
more time?
just so we're clear, we have taken plaintiff's original 48
Okay,
along with plaintiff's.
if you two are in agreement.
Uh-huh.
Oh, okay, go ahead, actually, sorry,
I
to
was
make the
just-
record,
yeah,
because you're
trying to-
telling me what we're taking out, which I
Yes.
appreciate, go for it.
We are taking,
The original 48 and
here it is, I'm sorry. So
49.
The original 46.
I think whatever deals with punitive is later in our pile of stuff.
You're taking the original 46.
Okay.
Which was the, gosh, I'm sorry. the
It wasn't
original
forced at the time of
48
occurrence.
The original 48 that put together the law, enunciating 484C.110. And we're combining it with the original 53, which was, jury instruction 12.3 and created a modified combination of those two instructions. And, based upon my review of what Joe has put together, I am, fine with it as of right now, just pending checking language.
So I'm just gonna put in my notes that in this spot, council created their own modification that I'll see when I see the final versions. Or the, whatever we get put together at the end of this immediately.
Got it.
Okay. So are we ready to go on, or Joe, you need, Mr. Chu, you need another minute?
Yeah, sorry.
No, take your time. You're the
Well, I'm
one
wondering
putting
if
it together.
the one we just created should go where the previous, so after the left turn statute.
That's where we're putting it for now. We might shuffle the order on these a little bit, once we are all able to confirm that the set you're working on right now has all the changes we're discussing right now. Okay, okay, so the next one, which was 49, which is probably like 42 or something, defendant Zaon Collins pleaded guilty. That one's out because we have an alternative.
Correct.
The next one,
Joe's just replacing right now.
I'm
The,
good. I'm good. I'll catch up.
okay,
so
you guys good to keep going?
So this is.
this is out, yeah.
Got it. Yep, we're good, Judge.
The next one, approximate cause of injury, this is out because we're doing legal cause, aren't we?
Correct.
Did we put legal cause in somewhere? We do have the definition of legal cause. We did put it in, right?
I put that in my proposed.
Okay, so it's in yours somewhere.
Yeah.
And you sent in that stack, so when we get to that, we'll put it in.
Sure.
Correct.
Okay. The next one in the order that we're going,
Want Joe to put the legal cause in it first?
Yeah,
if
Sorry.
he's ready, yes,
Yeah.
that'd be great.
He's trying to find the.
Oh,
Site.
okay.
Yeah, sorry, we just wanna
No, that's
make
okay.
sure we,
Go back to that.
don't miss it. I don't think we have.
It is Nevada jury instruction 4.4.
It's page 16 of hers.
Take hers, just go 16, and that includes the bracket language, right?
I believe so.
Wait. Okay.
It does have the bracketed language, a substantial factor. So will be replaced with page 16 in the
First,
version.
number 16.
Nevada jury instruction
There you go.
4.5
Take
with the
that
bracketed.
and put it.
For now, just.
All right, just put it next in line or?
Yeah, just put it next in line for now. We'll put it in a more appropriate place in a minute. Okay. Well, in probably half an hour when we finish. I hope we finish in half an hour. Okay, the next one is in with the only revision that physical and mental come out of line 21.
Correct.
Yeah, find,
Physical, mental,
Yeah.
come out of line 21.
the words physical, no, right there, you got it. Physical, mental, right there on, yep, 22. Keep pain and suffering, but take out physical, and mental. That's your ruling, right, Your Honor?
Yes, that's my
Okay.
ruling.
Understood.
Over your objection, yes.
Got it, thank you.
Or requesting to be included, whichever one you want to say. The next page,
Heirs plural. We change
Oh.
heir to heirs
Yeah.
in this
I
instruction.
don't have any problem
Yes.
with that. I think that's appropriate.
And I'm changing the he or she's to masculine because we do that on some of them. Like his or her habits of industry. That's actually the only one.
Okay.
Okay, the next one, I believe it's stipulated to plaintiff Anne Marie Echevarria is the personal representative of the estate of Eric Echevarria.
Yeah, that's stipulated.
Okay. So that one's in. And then the next one, defendant had a proposed one, right? That was different than this one. If you find that plaintiff is entitled to compensatory damages. This is the- Okay, so we've
Yeah.
fixed this one. This one's out because we have a different one.
Yep,
Okay.
Keep the insurance one, right?
Out.
and that's stipulated.
And then the insurance, yes. And then after that, how any verdict you render may or may not affect the defendants. This case is immaterial. This one was an issue, right?
You
Correct,
wanted
John.
brief, we had submitted a brief on this and then I believe there was I think you.
We're trying to get a brief ready on this. But again, I, just for today's purposes, I don't think that this is appropriate. On the, and I don't know if our responsive brief has been filed on this yet. But they also proposed like a corporation jury instruction to go along with this. The concern was
We're
that
not gonna give a corporation instruction, most likely. I don't remember exactly which one it is, but I know what you're talking about. Well, let's just talk about this one.
right. and
Okay.
so The concern, if I understand the concern correctly, it was concerns that were raised during the voir dire when plaintiff was questioning them about larger verdicts. And whether or not they could assess them against a corporation or an individual, and several members of the panel expressed concern about awarding a large amount of money against an individual, but then they also stated that they could follow the law on it. Plaintiff didn't object to cause for any of those, and I think that this is confusing. It is not Nevada law. The source that they cite for this is not Nevada law. It is not a pattern instruction, and it would not be appropriate here.
Okay, we have the sympathy instruction here, don't we? Your
Yes.
verdict can never be. I don't even see where it is.
Judge, may we respond?
Yeah, go ahead.
I appreciate it. The sympathy instruction is, in our view, very, tangentially related to what we're seeking to accomplish here. This is identifying a very specific concern, not as broad as sympathy. And here, first, there's no Nevada law to the contrary, or even anything remotely close. This is a very nuanced issue. We have not nuanced issues that we have no Nevada law on, so it's hardly a surprise that Nevada has not ruled on this specifically. But the law that we cited elsewhere is unanimous. We didn't go cherry picking, and it is indeed that the collectability of a judgment is immaterial, and should have no bearing on the jury's verdict. And Judge, we have 5 different examples cited in our brief, and I found 4 additional ones. 3 of those 9 examples, 4 of those 9 examples are from current panelists that we have, who stated things like, I'm sorry, I have to differ here. It has to be different for an individual as opposed to a corporation. An individual doesn't have the budget that a corporation does, and you're going to ruin that person completely and totally. This is from a current panelist. Another statement from a current panelist.
Well, I guess let's think about it. The flip way, there's actually an instruction in here that says a corporation gets treated as if they were any other party or something to that effect. Isn't there an instruction like that?
Correct, Your Honor. I proposed that later on. It was
No,
one-
you proposed the inverse of that, didn't
Oh,
you?
I,
Like the instruction is actually, hold on, because it's to avoid the opposite thing happening,
Yes.
where you award more against a corporation. So
Correct,
let me
correct.
just take a look at that, because
sure,
to see. I think that's, okay, one of the parties in this case is a corporation. A corporation is entitled to the same fair and unprejudicial treatment as an individual would be under like circumstances. And you should decide the case with the same impartiality you would in deciding a case between individuals. That cites to non-Nevada law. It cites to an Oklahoma case.
And well, Judge, in our brief, we have about 7 or 8 sites from federal, state courts elsewhere. And I know that we're all busy. It's hard to respond to trial briefs. But I defy anyone to find law that runs contrary to any of these sites, such as the collectability or uncollectability of a judgment. The operation of joint and several liability is simply not relevant to the jury's consideration of whether the defendants were causally liable and in what percent, or things like whether defendants are able to pay such damages is irrelevant to the determination of whether they are the appropriate remedy. And here we have basically half our panel has expressed these very concerns. And what we're not seeking to do is increase our award based on some, arbitrary language. We're trying to prevent an unjustly small award just because they don't want to ruin an individual, or they think, as one of our alternates stated, it is what's the point of going through all this if we know that they can't even collect it if the plaintiffs can't even collect it at the end? These were statements made on the record during jury selection, and this instruction cures that. And I did propose a cleaner version. I mentioned that earlier in the week. In footnote number 1 on page 2 of our trial brief.
I'm sorry, page 2 of your trial brief, you did what?
The wording was quite cumbersome. That's when I used it. Of the version of the jury instruction we submitted originally, and page 2 of our trial brief and footnote 1, I submitted what I purport to be a much cleaner and better worded version that we would kind of submit as an alternate.
And last but not least, Your Honor, the reason I did not move for cause on those jurors is because each of them said they could follow the law. And this is the law across the country. So if they can follow the law, I would hope the law would be read to them in a jury instruction on this issue. They can follow it. There's no grounds to remove them for cause.
And did
Yeah,
you want to say something?
Yeah, just, Your Honor, that this is not the law of this state. And so basing jury instructions on different.
Which part do you think is not a law in the state?
Seriously,
Because,
any of it.
I
I mean, we have
wait,
not
hold on
articulated
though,
this.
hold on, because no, you can't get up and say this is a corporation so you can award more. So you can't get up and say this is an individual, so you should award less.
Right.
Like neither one of those would be acceptable arguments, correct?
But no one's making that argument.
No, but they are concerned that that's gonna be in their mind. So do you think it's a misstatement of the law for them to say you can't award less because the party is an individual?
No, Your
When
Honor,
we're not talking about punitives, punitives are a
no,
different arena, obviously.
Yeah, and punitives don't apply to my client. So, no, my issue is just that if the Nevada Supreme Court or our legislature has not established this as a law, pulling from other states and putting it in front of this jury is inappropriate.
Well, but we could actually make the argument about a bunch of jury instructions, because like I said, if you look at the corporation as a party instruction 1.3. One of the parties in this case, is corporation. A corporation is entitled to the same fair and unprejudiced treatment, yada, yada, yada. It cites to an Oklahoma law. It cites to an Oklahoma case, not a Nevada case. There's no Nevada site underneath this. And if you go through a bunch of these instructions, there's no Nevada case law. No Nevada case is cited under a ton of these instructions. And the older the book is, the worse it is, as far as like citing other states. So, I understand what you're saying, that, hey, this isn't, there's no case in Nevada cited here, but here's, if this is fair law in Nevada,
Well, Your Honor,
Well,
I think you already addressed that it is covered under the concept of sympathy for the defendant. I mean, this is redundant.
can someone point out which one is the sympathy instruction? What
Yes,
number?
actually,
Where
that was
are
going
we?
to be my point, Your Honor. On page 15, we have Nevada jury instruction 5.2.
That also doesn't address the collectability concern, which was raised.
No fixed standard exists for deciding the amount of physical and mental pain and suffering, loss, and enjoyment. No fixed standard exists for deciding the amount of disfigurement. No fixed standard exists for deciding the amount of grief, sorrow, loss, nor is the opinion of any witness enough.
This doesn't talk about
You
sympathy.
must use your
Well,
judgment to
hold on.
decide. Yeah, this isn't the sympathy one.
Wait, hold on, I'm not done yet, and my point being that this instruction would be cumulative, because we start here. We start at page 15, we cite 5.2. We go to page 19 and we cite 5.9,
Hold on. There is one that actually,
and that 5.9 is the one that talks about sympathy. Sympathy. And then there's another one that talks about sympathy at
do you
page
do
20.
you have 1.5 in here?
Yes, 1.5 is at page 20. So that's my point. We have 3 instructions now that talk about the basis for determining damage and that you may not use sympathy. And then we also, in addition to those 3 instructions, have one on the insurance. So at this point, it becomes really redundant, first and foremost. And secondly, I reiterate, if this was an issue within the panel, then I think I raised an issue with some of the prejudice that I felt some of the jurors were expressing towards Zaon not being here. And I was originally prohibited from that instruction because I didn't strike them for cause. I think that applies here. They didn't strike them for cause when they expressed that opinion.
Can I just say something real quick? So
Yes.
the sympathy is in different instructions in different contexts. The first one on page 19, 5.9 is with respect to the plaintiff and the damages. Second one on 20, saying a verdict may never be influenced by sympathy. And neither of those apply to the issue we're concerned about here, which is collectability from the defendant, whether or not we can actually collect the judgment based on whether it's an individual versus a corporation. I think they're completely separate things, Your Honor. They're unrelated. I know this is not dispositive, Your Honor, but we have gotten it in other cases. We've taken a trial against individuals. Normally, it's not even objected to tell you the truth. I do believe it's the law in the state of Nevada. I believe it's the law across the country. We have not found any law that contradicts it.
I don't think it's a matter of whether or not there's law that contradicts it. I think it's immaterial in this case. And I think that collectability, we've hammered into this jury over and over again in voir dire, and we are going to hammer over and over again with multiple instructions that you may not use sympathy for any party in arriving at your decision. And those are the pattern jury instructions. And I would like to think even, we have pattern jury instructions from other jurisdictions. If this was a true problem, we'd have a pattern on it. That being said, I think that it is an overemphasis when we have 4 other instructions that talk about what you can and can't base your award on. But as a matter of compromise, why don't we include the collectability in 1.5? Right? So if we go
The
back.
sentence, whether or not the verdict you render is collectible.
Right, so instead of
Okay.
setting it apart in a 4th instruction on this, we include it in 1.5 as a line. You don't need to consider the party's collectability.
So we would just copy our instruction that we proposed and put it into 1.5 at the end?
You're saying copy the second
So I'm-
sentence?
So I'm saying a verdict may never be influenced by sympathy, prejudice, collectability of a party, or public opinion.
You said whether the verdict is collectible.
Yeah, I don't know that that's just collectability of a party is enough. I think we want the additional language. I think it's important just to explain. So why don't we just add in the second sentence?
Whether,
Well, if we're talking about that, the source of where or who the verdict may be collected from, maybe the right place to put that is actually on the collateral source instruction, the insurance one.
And that's where we've actually had it. We've actually done this before. We were combining it with that instruction before.
and we'd be fine with just the second sentence if we got it there.
Okay,
Yeah.
so if we put it on 1.07, then we could put whether not either party has insurance is immaterial, and whether or not either party is collectible is immaterial and should make no difference.
We prefer just to add on the second sentence of our alternate proposed, which reads, whether the verdict is collectible or where or from whom the verdict may be collected is also immaterial and should not be considered in rendering your verdict.
You're gonna put that on the collateral source instruction.
Yes, Your Honor.
I think it's appropriate there. I understand why it probably be appropriate on the sympathy one as well, but it might be more appropriate on the collateral source one because of what's being talked about already in that instruction.
I don't think the full language should be included. And I maintain my objection that it should be included at all. But with that compromise, if we're talking about putting it on to the collateral source instruction, I would say, why don't we say whether or not the verdict you render is collectible and whether or not either party has insurance is immaterial and should make no difference in any verdict.
Well, we already said insurance. I don't know why we would say insurance again in the last sentence.
Well, the last sentence says insurance, that's what I'm saying. So put in front of that, so that last line that starts whether or not either party has insurance. You start with whether or not the verdict you render is collectible. Or whether or not either party has insurance is immaterial and should make no difference in any verdict.
I think it's cleaner to have as a separate sentence, Your Honor.
I think it overemphasizes.
What is, which number is the insurance one right now?
54, it's the one right before the one that's in dispute.
Oh, it's right before this?
Yeah.
Whether or not either party has insurance is immaterial and should make no difference in any verdict you may render in this case. And you guys wanna put,
Well, language-
plaintiff wants to put the whole second sentence, right?
Correct.
Whether or not the verdict you render is collectible or the source of where or who the verdict may be collected from is also is immaterial and should make no difference in any verdict you render in this case.
Well,
And the defendant wants what?
Defendant wants to say in that last sentence on page 54 for Nevada 107, whether or not the verdict you render is collectible or whether or not either party has insurance is immaterial and should make no difference in any verdict you may render in this case.
I'll let you put the whole second sentence at the end of 54. And
Okay.
55 is out, the whole second sentence, and I understand your objection. But you can put the whole second, I think the whole second sentence is an accurate representation of Nevada law, even though it's not citing to a Nevada case. And I think you can both make that argument too.
Judge, we're gonna change it just to be grammatically correct to, or this, whether or not the verdict render is collectible, or the source of where or from whom the verdict may be collected also is immaterial.
I don't know grammar well enough to know, but sounds better.
Okay,
Mr. Chu is a real stickler on grammar.
just relative to my peers, Judge.
He gives me a hard time all the time. So, because I originally drafted the original instruction, he told me,
Now, there's gonna need to be like an opposite instruction in the punitive phase.
correct,
Okay,
and that's why it's the one actually proposed by defense, I think goes in the second phase.
okay. So this is out and that last sentence is gonna be a part of the one right before it, right?
Yes, Your Honor.
So let's keep going. Party must persuade you by the evidence presented in court. Is this one still in?
So this is the one where I proposed one at page 13. Because my objection was the mashing together of 2.1 and 2.A. So I took Nevada, I just did Nevada 2.1 without mashing it with the 2.A.
Do we have this somewhere in already?
I think we do. I think we already have, this is kind of duplicative. Based on one that we already put in that we just made changes to.
And that's the one that has the language about Marvin's under 41.4.
Correct. Do you remember which number it was?
I don't, unfortunately.
Hold on.
Cause this one has negligent entrustment in it too, and we're out negligent entrustment.
Correct.
I don't think we need both because they're basically,
Page 40, it's 2.1, you're right.
So this is already in.
So yeah, they had 2.1 and then they had a 2.1A. So yeah, this is already in.
This will be out.
yeah, I don't think we need this one. So
Got
find
it.
this one.
Okay.
It's this one.
So this page is out. Next one, every person has a right to expect every other person. This one's
We already
out.
have this, yeah.
Yeah.
Sorry.
Okay, next one, if the jury determines the plaintiff is entitled to recover, it shall return a general verdict. The total amount of damages the plaintiff would be entitled to recover from this accident, thus you are not to consider the negligence and the fault of any other person who has not been made a party to this. Why was this one in? I think it's stipulated, and if it's stipulated, I'll just leave it in, but is there a possibility that some other person other than the parties is at fault here?
Yes, I mean, so one of the jurors mentioned the paramedics.
Oh, good
That
call.
was one of their questions.
Oh.
Yeah.
I want to make sure they're not going to blame paramedics for,
Oh, for not moving fast enough?
correct.
Okay. That's
Okay.
fine.
I think the question was, is it normal to take so long
So we'll
to?
leave that one in. Okay. The defendant isn't objecting to it. The
Yeah,
next one, the loss of enjoyment of life compensates for loss of ability to participate and derive. Did we say this one was out?
You already
Yes.
ruled that this is out, Your Honor.
Next one, an award of.
I just want to make sure I'm clear. You also ruled that I can still argue it in closing because it's in a different instruction, is my understanding.
I believe that was probably true.
Because it's still in the standard instruction on what the damages are.
We'll check the transcript.
Yeah, that's like the transcript, but I think generally speaking, that's right. As long as you're not like putting it in front of the jury and close as this is Nevada law and what this means. But in argument saying, hey, this would include, in our opinion, blah, 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 blah. I think that's where. If I'm
Okay.
wrong, I'm wrong.
And I think what we said is I can use the common sense to decide what loss of value is
Right.
going to like. So
Yes, and that kind of gets us to this next one too, an award of suffering.
Yes,
Did
and I had
you-
objected.
I
to
don't
this
think
one.
we need this one in either. You can say that.
Okay.
But I don't think this needs to be its own instruction.
understood. So you're overruling my instruction. And this is out.
60 is out, yeah, or whatever page it is now. This one that reads, an award of suffering. You guys can say suffering can include, and as long as what you're saying makes sense, go ahead.
Understood.
Oh, and is it objectionable for some other reason, obviously. Okay, you're not
Yeah,
waiving all
yeah,
objections. Okay. Okay, the next one, were relevant evidence which properly, okay, let's talk about this one again. This is the inference. And I didn't hear anybody, this was my problem with this one, this is why I marked it, even if I gave this. Did we hear anybody say that they needed the vehicle? I didn't think anybody said they needed the vehicle, and I said, let's wait till see what Miss Detective Figueroa says. But he doesn't say that the vehicle would have done anything either, so I understand that I gave this in discovery, but I think this is just confusing, like what argument are you gonna make?
I understand, Your Honor. Our position is, the point of not preserving evidence and giving a sanction for it is we don't know what we don't know. So the jury has the right to presume that if it was preserved, it would have been adverse to the party that failed to preserve it. So our position is you don't have to establish what exactly it would have showed or what it would have been used for. All you have to establish is they failed to preserve it, and the jury automatically presume that if it was preserved, it would have been adverse to the defendant.
I think the case law is actually the opposite of that. You have to be able to say what you lost out on. And then based on that lost evidence, you can infer that that would have been negative for them. So if there was something about the vehicle that they weren't able to obtain, they have to identify that.
That's in order to obtain the spoliation order in the first place. Once the order is entered for the adverse inference, it is no longer our burden to maintain demonstration of what we lost out on.
That's correct.
I think it is correct, Tyler.
I assume so.
Let's have a let's have a Westlaw on this kid. We both know we wouldn't, neither of us would find anything in our states.
And just for my input, I agree. I don't think that this, I don't think this is necessary, and it's unnecessarily confusing, given the evidence that
I mean,
was
I just
presented.
don't know what other conclusions, like, I only heard witnesses as far as the Dodge go, give information favorable to plaintiff. I didn't hear anybody get up and say, if we had had the vehicle, we could have assessed X, Y, and Z, and that might have come down in the plaintiff's favor. Anything else? I think I gave this instruction, because at the time, I don't think everything was done.
I understand your ruling, Your Honor.
Yeah, this one's out. I think it's just, it doesn't make sense at this phase of the case with what we've heard and with what's come in.
So, just to make sure we're clear, is your honor reversing the, granting the spoliation motion?
No, but I'm saying this one has no relevance at this time.
Understood.
Because of what came out at trial, which nothing, so to give this would be putting a weird question mark in front of the jury for them to speculate. And I don't even know what conclusion they might come up with. Like, there's no doubt this was his car. I didn't hear, I also didn't see any benefit to the defendant
Mhm.
for not having, like, you have the speed, you have everything, so I don't know. I don't remember the exact terms of when this was awarded, but I'm not sure what,
Well, I guess my biggest concern would be if defendant somehow, or defense counsel somehow says that Sam Terry didn't even inspect the vehicles, the actual vehicle.
I won't say that.
We will
I
not
think-
say
Yeah,
that.
I don't care.
no, if they
Yeah.
say that, you get this back,
Okay,
okay? If that comes up in closing, I don't care if I haven't read it, you pull it out and I'll read it before they go deliberate.
understood.
okay?
Thank you, Your Honor.
If they say that, or I'll read it right after they say it, so be careful. If you do say that,
I have no
well,
intention.
nobody even
Yeah.
looked at the vehicles, that's a different story, but I didn't hear them say he didn't even look at the vehicles, so we're going to discredit him,
Understood.
okay?
Yep.
If that argument is made, that he's discredited by not looking at this vehicle and he didn't see the vehicle because it wasn't preserved, instruction comes back in, got it?
Zero intention to do that.
And Nora, my daughter has a play in 30 minutes and Miss Zinna has the last.
I've got his
our
notes.
Okay,
position
that's
the
up
last
to you
one.
if you wanna leave.
Thank you.
Yeah. So that one's out,
Play.
okay, so we have a few of defendants
home.
left, right?
Yeah, just a couple. We're almost there.
Okay. Let's go.
All right, did we want to start with, I have in my set the 513 filing at 6:32 PM.
I was looking at the
513?
515, but give me a second to find the 513.
Do I have the word version?
Oh, this is
This
ours.
is yours.
513 at what time again?
I was looking at the
6:32.
515.
6:32, here it is.
513,
There's two 513s, a 514, and then my set that I don't think I have anything new in.
This is
but
the
I'll-
NRS 41.440.
And Tyler is fine with that.
Wait, 513
513,
at 448?
yeah,
at 4:40.
632, so that
32.
might be it.
I have a 513, 756.
You're looking at the Word document, so it's gonna be different. Word documents are saved at a different time than the,
When
but that's it, you got it.
the PDFs were the same.
Yeah. All right, so this is the NRS 41.440.
Correct, and we're good with that.
Okay, so, and this is the only one where we're actually citing the statute just because it's being mentioned as
Yes.
claimed under, okay.
Should I just stick it at the end and with the tag to be moved, or is this gonna?
Yeah,
Yeah.
with the tag to be moved. If you're both fine with it, I don't have it in front of me. I'm just gonna trust that it's the correct
It's
statement of
fine.
law. As long as you're both stipulating it's the correct statement of law, and then even if it isn't at this point, it's your issue because you guys both agreed to it.
Oh, instead of proximately resulting from Zaon Collins
Legally.
negligence, legally resulting from negligence, yeah.
Oh, thank you for catching that, yes. I just glazed over.
There's
Mark.
approximately in the actual statute as well. Oh, wait, well, can we change that, Judge?
I don't think we can change the statute.
Which ones did you?
NRS 41.440 actually uses the term proximately.
Yeah, for any damages proximately resulting from such negligence. Or the shall,
I'm trying to pull up the instructions you guys are both citing right now, but all I
You
see
want my
is-
copy?
if you have another copy, yes, but if you don't.
It's
Okay.
totally, fine. I scratched out what I
I have
wrote on
one.
it.
I have a clean one.
Okay.
Clean one, I just found it.
It was
Are you talking about, wait, are we looking at the one Mr. Ladah gave? Is that what everybody's looking at right now?
Yes.
There is enforced a statute 41.440. Oh, I've got that one in front of me. I didn't realize we were looking at Ladah's, at plaintiffs. I thought we were looking at, that's fine. Go ahead.
It uses the word proximately in there where it says any damages proximately resulting from such negligence. I mean, I just don't want there to be confusion. Maybe we should change it to legally.
I don't think that having it in the one mention of it is gonna be too crazily.
You could put any damages ... resulting. You could take the word approximately out.
Yeah.
That might be the solution.
Can we just put a brackets so that something's removed and, does that make sense?
That's fine with me too.
Or can we just do it without the word? I mean, it's gonna just
I
look
think
weird.
Well, I think you either put ellipses
Okay, let's do the.
or
ellipses.
you put a,
Here we go.
Okay, we got it.
okay.
We put the dot, 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 like you
Okay,
said.
I think that makes the most sense
Thank you.
because then it's clear something's out of there, but you have not changed the meaning, the overall meaning of that, I
Right,
believe.
Thank you, Your Honor.
Okay, so I have no problem with this one.
Okay.
You guys are fine. We're
And then-
putting that in.
Yep.
Okay,
Okay, good.
and then what is the next?
I'm looking at plaintiffs 8:48 PM filing.
Just 1 second, Joe's saving, I'm sorry, he's,
I'm freaking.
Sorry,
Yeah.
Joe.
No, you're good.
don't-
Ramsey thought I deleted the whole.
I think he's gonna mess everything up if
Let's not do that.
we move on too
We're
quickly.
good. No, we're good.
Okay, so 513 at 8:48 is the next one.
513,
Proposed additional
848, found it.
modifications and additional to proposed jury instructions from plaintiff. Okay, so the first one, you should decide the case for and against each defendant separately. That's out, right?
That's, yeah, it's a duplicate at. Okay, so I think.
Well, we
plaintiff's
can't
issue
have
with
this one in anymore.
Yeah, I think we have to take this out.
Yes.
Yeah, and if
Okay.
this is a duplicate, if there is this in here anywhere, I think you get.
It
that.
is,
Agreed,
it's,
agreed.
it's
Yeah,
at
fine.
25.
Just go find.
1.13.
Just Google's, I mean,
Yeah.
just control F some of these
So
words.
I'm gonna mark that out.
Like
Okay.
put 4 of these words together and you should be able to find it.
Searching for the, yeah, he's taking it out right now.
Do.
Good job, Joe.
All right. I love the positive reinforcement, you guys.
You know.
Okay, so that one's good. Okay, then we have the limited purpose. Did we admit any evidence for a limited purpose?
We did
No.
not, this was the page 30 in the original set,
This one doesn't need to be in here.
and it does not need to be in.
Plaintiff seeks to establish a claim of negligence against defendants. Zaon,
Oh, no, too quick. Sorry, you're right.
Limited purpose is out.
Limited purpose is out.
Joe's-
Keep
Joe's doing a
going,
good
keep
job.
going, keep going.
Uh,
The next one, I think we already have that one in here. That's 41440.
We already changed that one, yes, Your Honor.
Yes.
Yes,
So we're keeping pace, right?
Yeah, the next one, the generally, I just changed the typos, but we already changed it in the
Okay,
set.
so we already have this one in too, so that one's fine. And then the next one,
This one, I also changed negligent entrustment to NRS,
this is already in, already.
oh, no, this one actually we decided was cumulative of the other one, so we don't even have this one in.
no, I think this is, we were on page 40, hold on, let me just check my note. No, we kept 40 in, but we took out,
We had one that looked just like this, except for it said negligent trustment instead of 41440.
Search for wrongful death. Yeah, see, this one's
You have
been,
nothing.
this one's been removed because it was cumulative of that other one that talks about the permanents. The
we
verbs.
left in 40 and took out 56. So 40 was 2.1.
Oh, do we have 2.1?
Yeah, we should.
Okay,
And
this is 2.18, though, I believe.
This is, no, this is 2.1, you just changed the negligent entrustment.
To 41440.
Oh, shoot, we must have messed something up then. We must,
This, if this one needs to go in, just stick it in.
okay, what we did, is we took out the 2.1 A, I believe. Or,
Yeah,
sorry,
we did take out 2.1A.
so what we did, somehow we deleted 2.1 instead of 2.1A.
So why don't we just put this one in? And make sure that this one doesn't say proximate anywhere.
Problem is 2.1A is the one that defines preponderance of the evidence, Your Honor. This one doesn't have a definition of preponderance of the evidence.
We have a definition, I believe, somewhere else, right?
More likely to be true.
I think if you were to control out preponderance of the evidence on the final set in front of Joe, I miss Mr. Chu, I bet you have it.
You have components of evidence.
So something has a definition on it.
Wait, 2.1.
Yeah, that's 2.1. So you don't have,
That is 2.1.
it's defined, but that's not 2.1, that's 2.1A is the problem.
Oh, wait.
It says at the top, more likely true than not. It has.
Yeah, you're right,
extra
you're right.
At the top.
Okay, so what we gotta do is we gotta replace what we have there, this one, with this one.
So we need to replace. This 2.
This, which is this filing, find this, it's called proposed additional modifications. Additions. Yeah, sorry, Your Honor, we'll get it.
Fine, you're holding the final set, so I'm just putting them together as best I can.
Just
and
don't
with the
want it to
hope
be
that
messed
what
up.
we come up with, and I do want us to kind of pick up the pace a little bit, because I want to get through
I
it.
know.
Yeah,
Right.
you're trying to, I'm sorry.
Here, this is the one we originally kept in. with the pizza. And then this is the one you're saying you want now.
Correct. I'm
So-
fine with both of them if you want, but it doesn't matter.
So I think if we just keep this one, that does what we need, because this is already in. So if we keep the one at 2.1 that we already had in, you guys already changed the 4.41.440 language. I think this gets what we need.
Utilitarian?
No, when I just did it, but I can undo it. So wait.
I actually like this one better. I mean, are you okay with that?
I need to take a look at 2.18, because that was my objection earlier. You guys had mashed those together.
Right. This one is 2.18, I believe.
Oh, wrong. That.
Okay, fine. Let's just go with 2.1. That's what you want, right, Stephanie? You want the other one and not this one?
Yeah, because these mash, I don't like the
Okay.
mashing.
Okay, I'm fine with keeping the other one and just removing
Okay.
this one. So,
Just look up when it's done, and we'll move on.
We're good.
Okay, so the next one we
Hopefully.
have here, you are good or you're not? Okay,
yeah, we're good.
if
Sorry.
you
Aaron.
find the plaintiff suffered damage as a proximate result of defendant's conduct, and that defendant is liable, is there an issue with this one or not?
This is 12.1, it's already in.
This is not, well,
Or,
this,
no, this is
this,
12.
so my position, Your Honor, just to be clear, I'm sorry. I think what we do,
I think 12.1 gets shown after they check yes,
Right.
or after they
think-
write yes.
Yeah, when we were talking about, actually, and I apologize, 12.3 is in. I had alternatively proposed 12.1 and we said no to that one. 12.3 was the more proper one. And then the rest of this language, I agree, gets shown after if they. check
Let's
it off.
pull this one for now, because we're gonna have to have a discussion after they go to deliberate to figure out exactly what the final instructions are gonna be if they come back with a yes for punitives. Okay,
Got
so
it.
this is off to the side as potential to give later. Okay, the next one, clear and convincing evidence. Do we have something that says what clear and convincing evidence is?
I don't believe so. I think this is
So
appropriate.
let's put this one next.
Okay.
And then the standard in a criminal case beyond a reasonable doubt requiring that the jury be satisfied to a moral certainty. Is there an objection to this one?
Yeah, I don't think it's necessary. I think we've cleared up the issues by stating that he's already been
I think
convicted of these.
you run the risk of confusion here, especially after you're saying that he's convicted, so you've already got civil liability here. You have statements in here that say you already have civil liability. I don't think you need this anymore.
as long as I'm able to explain to the jury that the standard in the criminal case was a beyond a reasonable doubt. It was a higher standard than the standard in this civil case, because I don't want defense counsel to argue he wasn't convicted in the criminal case and therefore you should not find him liable for the marijuana in this case. And the thing is, the criminal case is beyond a reasonable doubt, so it's a completely different standard, so they cannot, they're gonna confuse it if defense counsel argues that. Does that
Are
make
you
sense?
gonna make that argument that he didn't have a criminal conviction, so he can't get a civil liability for it?
Well, I think that conflates two different things. I am going to argue that he does not meet the clear and convincing standard because his expert stated it was only the preponderance of the evidence standard he could meet. And the expert stated that he couldn't get to the reasonable doubt standard, and he could only get to that line.
Did anybody ask him if he had the clear and convincing standard?
Well,
He said he could not meet it. He said he knew that standard and he was unable to meet it with his
can I
testimony.
clarify, Your Honor? He said that with respect to intoxication or impairment. He said with respect to whether or not the plaintiff met the per se law that was over the limit, that was a fact. And he said that was to over 99% probability because there was a tiny error rate.
0.12% chance.
Yeah, so
Okay,
I believe defense counsel is conflating two different things here.
okay,
but I'll
this
say
one's
that-
not gonna come in. I don't think we need it, but
But
If
this
there's
is, can I,
improper argument, you're gonna be able to object. I don't know what she's gonna say. But we're not gonna say no criminal conviction, therefore no civil liability. That's not that's if someone says that, I imagine there's gonna be an objection.
That's
And
very
I'm
wrong.
gonna instruct the jury that it's a different standard. And that's not the case. And you are not to make your ruling that way, or you are to disregard the last statement. Whoever is the objecting party can ask me to give an instruction that they think is appropriate. If it is, I will give the suggested instruction. If not, I will give one of my own.
I'm
Okay,
fine with that, Your Honor, I understand.
okay. So that gets through all of the 513. So what's the next
The
set?
next one was the corporation instruction. Now that I've gotten the collectability instruction, I don't need this, Your Honor.
Okay,
I'll waive this instruction.
okay, then we get to Ms. Zinna's instructions.
Yes, I think the only one left for me that is an issue. And I'm just flipping through to make sure.
We actually put in the legal cause on one, right?
We did. I think it's at page 20, and that was that stipulated instruction on the attendance of parties.
Was that in?
My filing
Okay, let's,
here.
do you have the Word version? Or you want to just type it?
It's in.
They already put.
No,
it
no,
in
no,
that
not
one,
legal
because I
cause.
remember Pulling it
Not legal
off.
cause,
Oh,
this one.
oh, this one. Okay, I can type it, but.
Go ahead. I mean, it's unless you want me to send it Word, it's not that.
Oh, okay.
I guess
And then
it'll be almost.
the additional instructions during the course of this trial may become necessary. That one you guys want me to give, right? That during the course of this trial may become necessary for the parties and their counsel to step away. They're not doing this to be disrespectful. So do you want to change?
Yeah, we
Yeah.
might need to put
This-
in past tense, because Mr. Lotta wanted to read it with the bulk.
It may have been.
Change the tense of that one and you can add it.
Right.
They were not doing this to be disrespectful to you. Right?
Okay, if you all over the weekend find typos, email each other. Say, let's change page whatever, and then when you come in on Monday. If, I might tell you what typos I found too on Monday, but if you're agreeing to any changes of typos, we'll make a quick change right before they're read. And, I might not have copies for all the jurors.
And you're gonna put them in order?
Yeah, but let's do that now with the 15 minutes we have,
Sure.
because I think this is all of them, right?
I believe so.
Yes, Your Honor.
So if, Mr. Chu, if you could send me your
Still
fi-
typing
okay,
the,
take your time.
Sorry.
When you have
Are
the
you
final version
serious?
put together, send it to me, email it to me, and I will print 4 copies for us.
That's
So
good.
everybody sitting here has a copy.
I changed one of
And I
Stephanie's
just know
comments to a
Mr. Mulder
semicolon.
doing it.
Yes, that's
Please.
gonna take a minute, and when he sends it, it's gonna take a minute, because I'm assuming it's at this point 60 pages, maybe?
Uh-oh, I mean, I have 47.
Okay, good. We can pause the.
Cause we removed quite a few and for that last set, we only added, I think.
It's okay, wait for her to come back to say anything else.
All right. Oh, that's right.
Thank you.
okay.
I agree that, to me, that's everything.
plaintiff, it looks like everything to me. Yeah.
Okay, so we're back on the record outside of the presence. I have counsel present in the courtroom, and you are confirming that the 46 pages of jury instructions include all of the instructions that counsel proposed, less any instructions that I made rulings on and excluded. Is that correct?
Yes, Your Honor.
Okay, great. So now let's talk a little bit about the order. Great job, counsel, by the way. I don't think a lot of people would have kept up in a way where it was organized and neat and we could actually do it.
Thank you, Judge.
So appreciate that. Okay. Let's talk about the order. Do you guys have any ideas of where, actually 41-440, the one in there seemed to be right after the instruction, so I don't know if that one actually needs to be moved, but I appreciate that you marked it as needs to move.
It's because I did that originally and then I just moved it when we had a second. And
Yeah,
Judge,
you-
I should have mentioned, the only other one is 12.1, which you said to set aside as one that was possible that we would put a pin in or.
I have 12.1 set aside with the proposed verdict form for punitives, because we didn't go over that either.
Yeah, so I put
But
that
we
back.
don't need to go over that. We'll go over that after the jury goes out to deliberate. We'll take a break. And then I'll have you guys come back in like an hour or two, or whatever you think you can do reasonably. How quickly you come back, we'll resolve that then, so that we're ready to go immediately if they come back with punitive. And we'll talk a little bit about how what everybody expects if they do come back with punitive too, so that we know, if anybody wants to prepare for that during deliberation, you can, if you aren't already. So with that being said, I do have that pulled. So the first one I have marked to move is 18. It's your duty as jurors to consult with one and deliberate. Why don't we just pull that to put toward the end? And the next one, the same thing, when you retire, I would pull that to put toward the end. Usually that's one of the last ones I read. And then, so that's pulling out page 18 and 19, just to put toward the end right now, but not sure where. Page 22, the purpose of the trial is ascertain the truth. I would suggest we make that like way up in the front somewhere, if everybody's okay with it. So maybe we put the purpose of the trial is ascertain the truth. Maybe we put it as,
Yeah, Ms. Joe?
page 3. Anybody have a problem with 3 or 4? Anybody got a preference of where that goes?
No, I'm fine with three.
I can move these if you
Oh,
want.
you're gonna
Just
move
give
them
me-
there and then we can,
If you just give me a second to move them
Sure.
after we talk about where they're all gonna go.
thank you.
So page 22 will become page 3. 18 and 19 I've just pulled for now, but we haven't put them in a new place yet. The next one I've marked is now you will listen to arguments of counsel. That really should be the last one. So I'll put that with 18, 19, and 26. We'll pull them to the side.
And I'm sorry, which page was that?
18, 19, and 26. Pull them aside because those are gonna be like the last 3 I read probably. As I said a moment ago, you have 28 as the claims and you describe 4.140 and then you put 4.140 right after that. I don't have any problem with that order. We could tweak that a little bit, but I think I'm just getting nitpicky if I move that anymore. But do we describe what negligence is? Because probably that one should come immediately after 28, but like I said, I think I'm just getting a little nitpicky.
Oh, I don't think we have a duty breach.
Causation.
Damages
Well, we
action.
have page 30, so maybe page 30 should be first and then
Yeah.
page 29 should be. So maybe we just switch the order of 29 and 30. So immediately after 28, which reads plaintiff seeks to establish a claim of negligence against defendant Zaon Collins. Plaintiff seeks to establish a claim under NRS 4.140 against defendant Marvin Collins. I will now instruct on the law relating to these claims. If the next instruction was what is currently page 30, generally everyone has a duty to exercise reasonable care when their conduct creates a risk of physical harm. Negligence is, and then it does define negligence. I know we're not going through the each element, but I'm not really sure we need to in this case where
Agree.
he's already saying he's taking some responsibility. So let's put that one there. And then after that will be 29, which says there isn't in there. I guess we should put there was in force. Or maybe NRS 1441440. Should this be phrased like this?
It is current.
Which one?
Okay, it is currently good. It's not just that it was in place at the time, it's this 4140. So maybe we do 4140 right after that. And then plaintiff is seeking damages based upon claim of negligence and negligence per se after that.
Mhm.
Is everybody okay with that order?
Yes.
Yes.
And then we don't get to anything with an order problem again until I have 40 marked throughout the trial, but that actually can stay there if everybody's, well, maybe we put this at the end too, like right before the last 3.
40?
Yeah, maybe we put 40, like, put it with the pile of the 3 that I pulled out for now.
That's fine.
Okay, then leave everything else in the same order. Clear and convincing evidence. page 45, is that in the right spot, or do you guys want that somewhere else?
I think it needs to go before the one on punitive damages, which is at.
I would agree, either before or after the punitive damage.
38, so I would say it needs to go either before or after 38.
Why don't we put it right after? Is 38 the first time we say clear and convincing?
Yes, 38 is the first time we say clear and convincing.
This might get a little confusing if we're then gonna talk about legal cause right
I'm
afterwards.
gonna suggest legal cause get moved to. Right before 35.
Any problem with that suggestion? I think we definitely do need to move legal cause. That probably makes sense right before 35. So legal cause becomes essentially what probably is maybe gonna be 34. Hold
You
on.
guys good with that?
Yeah,
Okay.
order really doesn't matter much to me, I'll be honest.
Keeping up with this in real time instead.
I'm looking to see where we talk about that.
Because we're not,
When we talk about legal
but the judge is
cause,
keeping them in order. so.
We mailed it in.
Well, usually legal cause comes because there's the negligence instruction, duty breach causation damages. But
we could
don't
put legal
have
cause
that.
after,
So we should probably put it right after whatever our negligence instruction is.
right before 29.
And actually, legal cause, that the negligence of plaintiff's decedent was a legal cause of his own death is 33. So maybe we put it right after 33. Is that the first time we say legal cause?
Legal cause, first time.
Does anybody have a problem with 39 instead of where it is coming right after 33? Which I think is the first time that legal cause is said, which says
It is the first time, Judge.
that the negligence, and I'm reading about a third of the way down the page, that the negligence of plaintiff's decedent was the legal cause of his own death. And I think it's in another spot here too.
Oh, no, I'm sorry, Judge. Two before that, the
First say it,
plaintiff is seeking damages based upon claims of negligence.
that says negligence was a
Yeah.
legal cause.
Legal
Okay,
cause,
that's
it says
probably
it
where it
twice,
should
yeah.
go.
Yeah,
So we'll make it page 32, or it'll go right after 31.
yes,
And then
before the preponderance.
where do you guys want, as used in these instructions, highway means? Where do you first say highway?
I think we say it right when. Do a search
I'll
for it.
find it. 36, the speed.
So,
So do you want to put it there?
so after the one that reads there was in force at the time of the occurrence of question of law, rate of speed one? You want it right after that one?
I think before,
Anymore, hold on.
That's
Oh.
35.
sorry,
That's the first time, based upon the order we have now, that speed comes up.
yeah, correct.
Okay.
Yeah,
I think we want-
35 is,
After 35, do we want the highway one
You
after?
want it? Yeah, are you referring to 35 as the speed one?
Yeah.
I think we want it right before that,
Right before,
yeah, just
Okay.
like we did for legal cause.
okay,
so you want highway defined before you say it in, there was in force at the time of occurrence in question of law, which reads. And then
Correct, I think that makes, isn't that how we just?
a lot of times
I
we're
think
putting
it
stuff
makes
right
it
after,
after,
but I don't
like-
care. It's you guys, like,
I'm fine with it going
Either
before
one.
or after.
I think it makes better sense after, but I don't have a strong opinion one way.
I don't know, I like it before, especially with the speed one, if I'm looking at this and I see
Okay.
over 80 miles an hour on the highway, I'm against the law every time. Yeah. Let's do it
Okay.
before,
so people don't care, so I'll just put it before.
we don't care.
And then, okay, so the three that I pulled out throughout the course of this trial, it's your duty as jurors, when you retire to consider your verdict, and now you will listen, I'm gonna put them in that order.
Okay.
So the numbers at the bottom are 40, 18, 19, and 26. I'm gonna make those the last four.
Okay.
Okay,
Those are the only ones you pulled out?
those are the only ones I pulled at, well, I changed the order of some of the other ones. I can go through every order I changed if you want right now with you guys.
If you, it's up to you, if you wanna pass us those, you want us to put them back in order, or do you wanna do it yourself?
I'm happy to do it if you want.
It's up to you, we can do it, we don't mind doing it.
Say again?
That's fine. I think this, let me just put it for the record what I did. Then
Sure.
I'd rather it be you guys, so if there's a mistake, I didn't make it.
We could do it, yeah.
Okay, so what I did is, the purpose of the trial is ascertain the truth. I now have that right after the second instruction. So it becomes page 3.
There you go.
Cause I think that should be an early instruction.
Okay.
And so it comes right after, the order in which these instructions are given has no significance as to their relative importance. Anybody have an issue with that, or everybody good with that?
No,
Good.
Okay, and then everything's the same until we get to. Page 34, every person has the right to expect that every other person will use reasonable care. And, oh wait, hold on, sorry. Everything's the same until 28. Plaintiff seeks to establish a claim of negligence. And then right behind the plaintiff seeks to establish a claim of negligence, instead of it being the NRS 41440, generally everyone has a duty to exercise reasonable care when their conduct creates a risk of physical harm to others. You fine with that? Okay.
Fine.
And I'm gonna hand these to plaintiff's counsel in a minute too. And obviously all the yellow stuff can be taken out.
yep,
The next one I changed was after plaintiff is seeking damages based upon claims of negligence and negligence per se against defendant Zaon Collins. Immediately after that, I put a legal cause of injury, damage, loss, or harm is a cause that is a substantial factor. Because we're defining stuff right after we say it, I think. For the most part.
right.
We're pretty much.
Okay. And then the next one moved is I put immediately after every person has the right to expect that every other person will use reasonable care. I put, as used in these instructions, highway means the entire width. So the highway inspection is there. And then right after that is there was in force at the time of the occurrence. And then I didn't move another one until we got to, there was a law in force at the time, which goes to the marijuana law. And then right after it, I put clear and convincing evidence, the definition of clear and convincing. And then the next ones moved are those 4 at the end. Okay, I will hand these to you, counsel, if you want to check them against your set. But Ms. Zena, you agree with that, right?
I do agree with that, and that's the order I have them in.
You want us to check out the yellow and email them when we get back to the office, or?
You can email them right now if you want. I can print more sets for people if you want to do this right now before you leave. Is he closing his stuff down?
Oh, no, we are not, Judge.
I have the order. I was keeping up in real time, so I'm okay.
Okay,
If you guys just want to email it
yeah,
to me.
we'll just email, we can email in the morning, is that okay?
Yeah, that's fine.
And sorry, Judge, I wasn't trying to, I know you and your staff are staying late, that's why I was trying to expedite
Fine.
the exit.
If you guys are fine, I'm fine with it.
Thank you, John.
Just send me the set. I will number them exactly as they are.
Great.
Unless, does anybody anticipate potentially having any more?
No, we got it.
No, I can't.
Okay,
We
Then
did
I-
notice one typo on one of them, and if we could just email that and correct it.
yeah, any typo, if you guys are in agreement, that's fine.
Thank you so much.
Thanks, guys. Have a good
Yeah,
night.
thank you to
Have
your
a good
staff,
weekend.
thank you.
See everybody 9 o'clock in the morning on Monday.
Thank you for everything.
I thought, are we starting at 9?
Well, I
Or-
told the jury 9:15, so I assume 9 for us, just in case there's anything we need to do.
Okay,
Does anybody feel like that's not gonna be enough?
No, I don't believe so.
no, I think that's fine for Monday. I just want to make sure, because I think we had originally discussed maybe 8. But 9 is better.
I told the jury, I mean, if you guys have something urgent, send a request. And I will get here as early as I can, but 8 o'clock's probably really difficult.
Thank you.
Thank you, Aaron.
Thanks.